Hello guys, let's begin. So today in this video I am start from establishment of federal courts, and we will be continuing with what we left in the earlier video. Establishment of federal court. The Government of India Act 1935 changed the structure of Indian government from unitary to that of federal type. Now, when I read this line, a question comes into my mind, and you need to find out the answer to that question on your own. And if you find out on your own, that means without searching for it anywhere, then that's a very good sign. Otherwise, you can search for it in your books or in your reading materials, or maybe you can Google it directly. That's totally upon you, but you need to find out a question that, as per the Indian Constitution, which form of government India has in present day situation. Okay, that you need to find out. So by this act, it is important. I always say that wherever the acts come, their years and what all is mentioned in that act in a brief manner, you must know all these stuff. So the Government of India Act of 1935 is one in which the structure of Indian government, or the structure in which the Indian government is what the Britishers at that time, because it's of 1935 scenario. So Indian government of that time changed from unitary to federal. Unitary means there will be only one unit that will govern the whole nation, and federal means there will be one unit, but there are some sub units also that need to work under this unitary or union government, and there will be some state governments, and this is what we have today also, right? So basically that was given by this act only. The present day system, the present day governance or administration is much admired and influenced from this Government of India Act of 1935. Distribution of powers between centre and provinces required the balance to avoid disputes which would have arisen between the constituent units and the federation. Now, one thing over here, today we have centre and states. At that time, that is pre-independent era, we were not having any such divisions like states. That happened after we got independence. So before the independence, or when the Britishers still ruled over us at that time, we have had center and provinces. Okay, so right now there is distribution of power between center and province and states. We have a center government and we have state governments for various states that we have in our country today. But in earlier scenario, pre-independent India, there was center and provinces, and power was distributed or separated among them. And why this was distribution of powers? Because if power was concentrated in one hands, or if it is not distributed accordingly or in a proper manner as mentioned somewhere, so there is a dispute that you don't have this power is with me. No, if it is mentioned somewhere, then it's very much clear that this is something which is under your arena and this is something which is under my arena, so as to avoid any sort of future disputes, right? If it is mentioned somewhere that these are, or this is the manner in which power is distributed, so now there is no question of dispute or no question of any matter that whether this falls under your or mine jurisdiction, because now it's clear if it is mentioned somewhere. So that was the part which Government of India Act of 1935 played. It distributed the power so that there is a balance, and also the future disputes can be avoided. The system of federation clearly demanded the creation of a federal court which would have jurisdiction over states as well as provinces. Now, federal government, so federal court that would be established, and that would have the jurisdiction over the states, provinces and all of India. Original jurisdiction was confined to disputes between units of dominion or between dominion and any of the units. Now, as you may have studied in your previous classes as in 8th or ninth in civics, that any court in India has various jurisdictions: original jurisdiction, appellate jurisdiction, right? So the original jurisdiction means the matters which come directly to that court of law. For that suits, it exercises the original jurisdiction. So original jurisdiction is confined to the disputes that are between the units of dominion, means organs of the dominion or the government, and between the dominion and any of the units, means between the central government and its organs if there is a dispute, and between the center government and any state government there is a dispute. So at that time, the original jurisdiction can be exercised of the federal court. The private individuals had no right to sue any dominion before the federal court, means any government part, any organ can't be sued by a private individual. Means we as a private person, like I am a private individual, you who is listening to this right now, you are also a private individual, so you can't directly sue in the federal court. The federal court had appellate and advisory jurisdiction. Its appellate jurisdiction was extended to civil and criminal cases. Supreme Court was also established on same principles and jurisdiction. As I have told you few minutes before only, that there were various administration or governance systems that were admired from this act, and that we took also from the Britishers. So the Supreme Court of India that we have in existence today, the principles on which it was established, the jurisdiction, kind of jurisdiction that it exercises, that all has come from this act. And the federal court, as I told you, there are various types of jurisdictions: original jurisdiction, appellate jurisdiction, means the cases or the suits or the matters that come as an appeal to that higher level court of law from the lower courts. So an advisory is when you are bound to give some sort of advice to the government officers as in PM or president. So these are the three types of jurisdictions that the federal court of that time exercised, and that all same things are also with the Supreme Court of India. And also its appellate jurisdiction was for both civil and criminal matters. So you see, if it is asked, if there is a question in the examination that what was the jurisdiction of federal court, then you have to say that original jurisdiction was between units of dominion and the units. Private individuals can't sue, that will also be included, because that is where there is a limitation or restriction for the jurisdiction of federal court, that private individuals could not come under it. Then private individuals, as in they can't sue it, okay, they can't sue the government actually. And appellate and advisory jurisdiction also, it exercised appellate in civil and criminal matters both. Section 200 of Government of India Act 1935 created the Federal Court at New Delhi. Very important, underline this and learn it. Which section, which year created the Federal Court and where? So Section 200 Government of India Act of 1935, by this Federal Court was created at New Delhi. An appeal from any judgment, decree or final order of a High Court was entertained by the Federal Court if High Court certified that the case involved a substantial question of law in accordance with interpretation of Act of 1935 or any other act or law. The certificate was a condition precedent to every appeal. That means you have to certify, or the High Court needed to certify that this particular matter or this particular suit gives rise to a substantial question of law, and we are not dealing with it, but the federal court, being the apex or higher level of court, we are requesting you to deal with the matter and to interpret or to implement the provisions of either either the Government of India Act of 1935 or let it be any other act or law which was prevalent at that time in India, because obviously you have to deal with the situation according to the acts that are present in place at that time, right? फ्यूचर में क्या लॉ पास हो रहा है या पास्ट में क्या था उससे आपको मतलब नहीं, एट प्रेजेंट जो आपके पास लेजिस्लेशंस या अमेंडमेंट्स या एक्ट्स हैं आपको उसके साथ डील करते हुए उस मैटर को सॉल्व करना था। तो हाई कोर्ट से एक सर्टिफिकेट अप्रूव होना बहुत ज़रूरी था कि अगर हम अपील में जा रहे हैं फ्रॉम हाई कोर्ट टू सुप्रीम कोर्ट तो एक सर्टिफिकेट के साथ जाना होता था कि दिस केस इन्वॉल्व्ड a substantial question of law or of a principle of any act, and so the Supreme Court now has to intervene in between and interpret as it feels or whatever its discretion is to solve this matter. Then advisory jurisdiction, federal court was empowered to give advisory opinion to Governor General whenever a question of law arose or was likely to arise which was of such a nature and of such public importance that it was expedient to obtain the opinion of federal court upon it. Now see, Governor General need not to be an expert in the legal field or a person who knows everything about laws or legislations and how to deal with the situation. See, nobody is perfect, right? We know that. So Governor General need not to be a person who is having a rich knowledge of laws or legal scenario at that time. So sometimes the situation arises that the person has to take an advice from the federal court, like what should I do in this and that situation. So for that the federal court had the advisory jurisdiction. At that time federal court had the power that it could give an advice or suggestion to the Governor General only if the Governor General asked it to do so. The court after such hearing reported the matter to Governor General thereon. So obviously first you have to tell what the matter is, you have to present the matter or the dispute before the federal court, and after that proceeding or hearing, now whatever the decision or whatever the suggestion would be, that would be reported or reverted back to the Governor General. Appeals on decisions of federal court had to be taken up with the Privy Council in London, which remained the final arbiter of all matters of Indian legal system. So still, what was the situation? That the apex court of law for an appeal to have in India was not the federal court, but for India the apex court of law at that time was the Privy Council that was situated in London. The federal court functioned only for 12 years and gave way to the Supreme Court of India in January 1950. So it was established in 1935. So for next 12 years till 1947, when India got independence, till that the federal court was in existence, and this federal court then got converted into the Supreme Court of India in 1950. However, it left a considerable impact on Indian legal system. During its existence, federal court decided 151 cases. So auspicious number it is. Just joking. 151 cases it had decided or solved. Some of these involved issues of critical importance to federalism, its own advisory jurisdiction, and in some cases issues such as preventive detention. There may be various problems or various issues that people could face, right? So all those matters can be taken up to the court. समटाइम्स दैट लाइक इट हैपन्स इन टुडे, वैसा ही कुछ पहले भी होता था. लोग तो वही थे, इंडिया वही था, इंडिया के लोग उसी मेंटालिटी के थे. तो लाइक इंडिया में आज होता है कि सुप्रीम कोर्ट के ही जो प्रोविजंस कॉन्स्टिट्यूशन में लिखे गए हैं कोई उसको चैलेंज करता है. दैट recently it happened, I mean 1.5 years back, that whether CGI office would come under the ambit of RTI, that is Right to Education Act, Right to Information Act or not. So ये क्या है, सुप्रीम कोर्ट का ही एक पावर है या सुप्रीम कोर्ट का ही एक प्रोविज़न है जो कि क्वेश्चन में लाया गया कि क्या ये चीज़ हो सकती है या नहीं. और कोई कॉन्स्टिट्यूशन के प्रोविजंस के मैटर्स को भी हम लेकर जा सकते हैं सुप्रीम कोर्ट में कि कॉन्स्टिट्यूशन में अगर लिखा है दैट राइट टू लाइफ is granted to each and every citizen. The right to life by Article 21 of Indian Constitution has a very wide ambit. उसका एम्बिट, उसका एरेना बहुत ज़्यादा बड़ा है. आप कोई भी चीज़ बोलो, राइट टू क्लीन इन्वायरमेंट, दैट इज़ अंडर राइट टू लाइफ. राइट टू ब्रीथ क्लीन एयर, दैट इज़ अंडर राइट टू लाइफ. तो ये सब चीज़ें किस तरीके से इंटरप्रेट की जाएंगी, वेरियस प्रोविजंस कॉन्स्टिट्यूशन के किस तरीके से इंटरप्रेट कर कर उसको किस तरीके से आप प्रेजेंट सिचुएशन में इम्प्लीमेंट कर रहे हैं, यही काम होता है जजेस का. ठीक है, उनके पास वही गिनी चुनी चीज़ें हैं, वही गिनी चुनी रूल बुक्स हैं जिनको एट जो उस टाइम पर एग्जिस्टेंट है, जिसको उनको रिफ़र करके अपना वर्डिक्ट सुनाना है. तो वो किस तरीके से काम करते हैं, इंटरप्रेट करते हैं. कोई भी राइट टू लाइफ है, रिसेंटली केरला हाई कोर्ट का जजमेंट था दैट राइट टू इंटरनेट इज़ अ पार्ट ऑफ राइट टू लाइफ अंडर आर्टिकल 21. दैट वाज हैपेंड एट द टाइम ऑफ एंटी CAA protest when there was 144 imposed anywhere and everywhere, and the internet supply was shut down. So at that time this judgment came that right to internet is also under right to life. So how you have to interpret this simple term right to life to include various other things under its ambit? That is how judges do it. So you have to deal with the matters, right? Advisory jurisdiction है तो आपको कोई एडवाइस ले रहा है तो आपको उसको कैसे एडवाइस करना है, अपेलिएट जुरिस्डिक्शन कैसे एक्सरसाइज करना है, यही सब काम आए दिन कोर्ट में चलता है. Now we come on to establishment of other high courts and Supreme Court, and this I will take up in the next video.